Questioning is one of the most important steps in a negligence lawsuit. Cases can be won or lost at questioning. Now, this is not a pretrial activity, it's not the actual trial. And sometimes it's often the final step for the physician, as most cases are settled or dropped after this point. In reality, nobody really wants to go to trial if they can avoid it, and the courts would much rather that we just sorted this out ourselves. So after reviewing all of the documents, this is where both sides get to ask questions of the other side to fill out the details of the evidence so there are no surprises at trial. The purpose of questioning is to help each side fully understand the strengths and weaknesses of their case and often encourages settlement. It gives both sides also an opportunity to evaluate the witness's strengths and weaknesses and an opportunity for the other side to get admissions under oath, which they can then use against you at trial. Before your day of questioning, there are a few things you need to do in order to prepare. First thing to do is meet with your lawyer. They'll go over what to expect and give you some general guidelines. They're also going to size you up as a witness so that they can better prepare you as well as themselves for questioning. Occasionally, they may do a mock questioning session in order to give you a sense of what to expect. Remember, this is their territory and not yours, so don't be afraid to ask questions. The guidelines your lawyer gives you are very important, and you should pay attention and take their advice. Next, you need to review your notes and the chart to refresh your memory of the case. It's a good idea to practice reading your notes over out loud so you don't stumble over words you'll eventually be asked to explain, and also make sure you know all of the abbreviations you may have used. Questioning usually occurs well over a year after you submitted your statement of defense, so you'll probably not remember what you wrote at the time. Then the next step is to get a haircut and get your dry cleaning done, because presenting yourself professionally shows respect for the process. In case you didn't know, questioning doesn't occur in court, so don't go to the courthouse. You'll probably be at your lawyer's office and occasionally at the patient's lawyer's office, whoever has the nicest digs, I guess. You should plan to arrive a bit early so you have time to settle and not feel rushed. Now, it is normal to feel nervous, so take your time. First thing that will happen is you will be taken into a separate room with your lawyer, who will brief you again and for the final time. This is your chance to ask any last-minute questions that you may have. They will have met the questioning lawyer, and they may be able to give you some sense of their style or the general direction of the questioning. They will not be able to tell you what to say in answer to questions. This would be very unethical. Then it'll be time. You'll usually be brought into a large conference room where you'll be introduced to the patient's lawyer and a court reporter. Depending on the circumstances, there may be other people there to observe, including the patient, patient's family, and other lawyers such as the hospital lawyer. None of these people will be involved in the questioning, so try to ignore them. The one thing I cannot emphasize enough is that it is a routine thing for the lawyer, so while this may be a big day for you, it's Thursday for them. So don't misunderstand any relaxed attitude on their part for a lack of concern. Lawyers are professionals, and they do this all the time, so they know what to watch for, and they are paying attention. Remember how you feel when you're doing a procedure or an operation you've done hundreds of times. You're relaxed, you're prepared, but to an outsider, you may seem blasé, or even though you're about to do something really dramatic, like cut somebody open. Also understand that medical legal lawyers are a specialty group who interact with each other on a regular basis. They know each other, and none of this is personal, and chances are both sides know each other so well that you shouldn't misinterpret any friendly banter as collusion between both sides. A lawyer's professional responsibility is to their client like yours is to your patient. So when the questioning starts, the gloves come off. And trust me, I've seen my lawyer go from discussing the weekend events to arguing stridently over a point of law the moment we started on the record. It's really impressive to watch. That being said, this is not like what you see on TV. During questioning, your lawyer is only there to object to unfair questions. This is a specific class of questions and not questions that you don't like or where the answer may make you look bad. You must answer all questions unless your lawyer objects, and your lawyer cannot help you answer those questions. They cannot speak to you nor coach you about the evidence prior to, during questioning, and not even during breaks. You will be able to debrief afterwards, which is a good chance to get some feedback on your performance so you can improve for the next time. And the first time I did this, my lawyer told me that essentially we would be walking into a conference room with a very large briefcase full of my money. How much of that money I left in the room when I walked out largely depended on how I performed during questioning. In case it's not blindingly obvious, both just by common sense and having to swear an oath, you must always tell the truth. Under no circumstances should you ever lie. And don't guess. There is no faster way to blow your credibility and lose a case than to lie. The whole point of this activity is to answer questions. And this means that you must answer all of the questions that the lawyer asks you. It's important that you listen to the full question without interruption. Before answering, stop and think about the answer. If you don't fully understand the question, then ask for clarification. And you can do this as many times as necessary until you feel you get the question. When you answer, you should always keep your answer short and on point. Less is more in these cases, so try not to ramble or expand on your answer. If a simple yes or no will do, then say yes or no and then shut your mouth. If you don't know the answer or you can't recall, that's okay. Just say so. No one is going to judge you if you can't recall some minor detail from 5 years ago. As I've said before, my memory is terrible and I don't try to force my memory. I just look at my notes in the medical record. That's why it is so important to have contemporaneous notes. You don't have to justify your inability to recall nor explain, and you certainly should not suggest another person who may have the answer. That's for them to discover. As well, do not answer any questions that are not asked. If you think the lawyer is implying something, don't help them by answering the question that they're not asking. Let them ask that one explicitly. Now, if your lawyer raises an objection, stop talking immediately. Let them sort it out before you proceed. Remember, anytime on TV when a witness overrides his lawyer's objections, it's usually gone very badly for that witness. Probably one of the most important tips to remember is to leave your ego outside that room. You're in their territory, so it's better to act like a guest. And without exception, do not ever, under any circumstances, try to argue with the lawyer. They're the experts at arguing. You're going to lose. Also, never insult the lawyer or the patient. No case has ever been won by the physician being a jerk. Never lose your temper. It's also not a good look on you. And don't try to argue the merits of the case with the lawyer. Never in the history of ever have lawyers put up their hands during questioning and said, "I see your point, and clearly you are right. I give up." You can't persuade your way out of this case during questioning, so just answer the questions. For most people, questioning is the most stressful part of a negligence suit. It combines all of the pent-up emotions since the start of the lawsuit and places you in an unfamiliar environment where the stakes are high. Understanding the process and following some simple rules will go a long ways in making this a lot less stressful for you. Furthermore, a good performance will help show the other side that you truly are an excellent physician and the professional that you are. The next step after all of this, the witnesses and everybody's been questioned, is for the lawyers to meet and discuss who to drop from the lawsuit. A poor showing at questioning will make it harder to get you dropped from the case if you weren't truly involved. As well, after questioning, both sides are going to make a decision about whether to pursue the case, or drop it, or settle. Both sides can't come to an agreement, then the next step after this is to proceed to trial. Now, in all of my years of experience, I've never had to settle, nor have I ever gone to trial. In each case, I've been dropped from the lawsuit. So we will conclude this series on that point. Hopefully, you will now have a better understanding and appreciation of the medical negligence lawsuit and your role in the process. No one likes to be sued, but this doesn't mean that the whole thing has to be as unpleasant as it is often made out to be. Never forget, lawyers are professionals who are doing a job to take care of their client just as we take care of patients. A little bit of understanding and a lot of respect on our part will make both of our jobs an awful lot easier. Thanks for watching this series. I hope you've taken something away from this, and I hope that when you're eventually exposed to a lawsuit, you now have a better understanding of what to do and what to expect. Thanks for watching.